Welcome everyone. This is Bill Harris, CEO of BIP Wealth. I want to thank everyone for joining us today for a panelist discussion about estate planning and trust. We have three panelists on the call with us today, and I'll introduce each one of them. But before I do, Nate already referenced the structure that we're going to use, which will be 20 to 25 minutes worth of me asking a couple rounds of questions, and then we'll open it up to the audience to type in your questions to ask the two estate planning attorneys and the advisor that we have on the call. So with that, I'll go ahead and introduce each one of them. Sarah Watchko. Sarah, feel free to wave to the group. So Sarah's been an estate planning attorney for 12 years, and she's a partner at Hill & Watchko Law Practice. We also have Tim Curtin. Tim Curtin has been an estate planning attorney for 27 years, and he founded and runs the Curtin Law Firm. And interesting fact about both of them, coincidentally, as we were scheduling this, realized that both of them got their law degrees from Wake Forest University. So there's a nice little commonality here. So I don't know if we have any Demon Deacons on the phone, but they are well represented on this panelist discussion. So the third panelist, JP Scott, who is one of our personal wealth advisors at BIP Wealth. JP has been in the business for 16 years, the last 5 years with BIP, and JP has earned his Certified Financial Planning designation along as a Chartered Financial Analyst. First question is for Sarah. Can you go ahead and give us a brief overview of the documents that are part of an overall estate plan?
Yes, I would love to. When I'm talking to families, I refer to the estate plan as a package. And part of that package, there are 3 documents that I think make up the bare minimum of what everyone should have. So the first one is the last will and testament. Most people are familiar with this document. It says who gets your stuff when you're gone. And stuff is a very technical term I like to use to describe your assets, your bank accounts, your investments, your real estate, anything that is in your name. And you name an executor who's responsible for carrying out those directions, for handling the transfer to beneficiaries when you're gone. The will covers everything that's in your individual name when you pass away, but it may not control assets that are titled jointly, and it will not control accounts that have a beneficiary designation like an IRA or life insurance. So it's important to know the limits of what it does too. And if you don't have a will, then state law determines who gets your property when you're gone. And many are surprised to learn that if you're married and have children, your assets would be divided between your spouse and your children. So my 3- and 6-year-old could inherit part of my estate, and that would be a disaster in a lot of ways. Power of attorney is the second document of the package. This is who you name someone in the document who can act on your behalf if you're no longer able to manage your own affairs. And it really covers everything that you do day in and day out and kind of take for granted that you can do, like access your bank account, pay your bills, manage property, sell property, call your insurance company, call Georgia Power where the account's just in your name, file an income tax return, sign a contract, file a lawsuit. All of these things we take for granted. If I'm not able to do it, no one else can unless I have this document. That's the power of attorney. And last is the advance directive for healthcare. This is where you can say who makes medical decisions for you if you can't communicate. So some other terminology you hear is a healthcare power of attorney or proxy, a living will. In Georgia, it's all in one document, the advance directive. So you say who can make healthcare decisions, and you also have the opportunity to state your treatment preferences if you had an end-of-life scenario like a terminal condition or a state of permanent unconsciousness and you couldn't communicate for yourself. So the will, power of attorney, and advance directive for healthcare, everyone needs one.
Perfect. Thank you, Sarah. That's a well done overview of the 3 documents that are part of that basic estate planning package. Tim, a question for you. One statement that you've made to me before is beneficiaries can ruin an estate plan. And I'm very interested, in your perspective on this. And so if you wouldn't mind addressing that and sharing that with our audience.
Yeah, absolutely. Thanks, Bill and Nate, and hello, everybody. As Sarah touched on this in her overview very well, many of us are under the mistaken impression that a will controls how all of our assets are distributed when we pass away. And I'm finding more and more as our assets allocations change that fewer and fewer of our assets pass according to the will, but rather pass according to what's commonly known as a beneficiary designation. The three most common assets that I see that pass according to beneficiary designations are your retirement accounts, your 401ks or your IRAs. Your life insurance also passes by beneficiary designation. If you have any annuities, they will pass according to beneficiary designations. And many of us, when we establish these accounts, we're filling out so much paperwork, we're not paying attention to who we filled out as our beneficiary. Now, if you're a married couple, you've been married for a long time, probably won't be that much of an issue because you probably named your spouse as the beneficiary of the designated beneficiary of these assets. The real problem can come in if your spouse has passed away and you have children. A very common error that I see is that you have named your spouse as the outright beneficiary of your life insurance, and then you decided when you filled out your beneficiary designation form, you named your 3 children as the contingent beneficiaries if your spouse isn't around. But when you did your will, you wanted to have a trust established for your children so that money could be protected for them until they reached a certain age. Unless you coordinate the beneficiary designation on the life insurance to make sure that those assets pass according to the trust, the beneficiary designation always controls over the will. And another common unfortunate situation is if you have been divorced and you haven't updated your beneficiary designations, those assets could still end up passing to an ex-spouse if you don't update your beneficiary designation.
That's great. Thank you, Tim. JP, this question's for you. You work with a nice sizable practice at BIP Wealth, and you're having these conversations with your clients about estate planning. And what sort of role do you play in helping your clients prepare for an estate planning meeting?
Yeah, sure. So I try to think of it in a few ways. And when I saw the poll question that 2 of the respondents said that they don't have an estate plan, I know that we addressed it a lot when we asked some initial questions, but even as financial advisors, we sometimes get sidetracked and forget to ask in every meeting because of what's happening in the markets of the world or, with cash flows and different things. So I would ask that any of those clients that as we address it from time to time, we always want to make sure that we are continually addressing to make sure, number 1, that we have a estate plan in place. 2, that if they are old or outdated, that we're also going back to revisit them. And when I'm thinking about preparing our time to try to get in front of that estate planning attorney, it comes down to the who, what, when, where, and why. And if we can always be thinking about those questions, I think that can guide us to prepare ourselves for that meeting, or when we're trying to go back and sit down with an estate planning attorney. Maybe one of those 5 things has changed. So when I'm thinking about the who, what, when, where, and why, the who is, who do we name in these documents? Who are we giving the assets to? But more importantly, I think of as who are we asking to serve? So who are we asking to serve as our executor? Who are we asking to be our power of attorney? Who are we asking to possibly be a guardian or trustee? And so when you're thinking about the who, then you're asking about the what. What are we asking them to do? What does that role entail? So if I'm asking someone to be a lifetime trustee for a special needs trust, that's a lot different than if I am asking them to be the executor of a document or to be a financial power of attorney. And when I think about the when, it goes right in line with that. How long am I asking them to do something? When am I asking them to step up and participate? The where comes into where are they? Where are these people, but also where are these assets? Tim just brought up a great point of some of these assets are going to be controlled by our beneficiary designation. Others are going to be dictated by the will. But we have to think about where are not only the beneficiaries, but the people that we're asking to serve in a role, and what does that role entail for what they're going to ask to do. And then there's always the overarching why. Why do we think that maybe we need more complex structures? I brought up the idea of a special need child or a special need grandchild. Maybe I have young children. So what I'm asking for someone to be a guardian to actually raise my children if something happens and they're very young, or an executor, right? The executor function, maybe we trust someone greatly, but they're not the greatest at administrative tasks, or they're on the other side of the country. So trying to coordinate who it is that we're naming in this document, and then what we're trying to ask them to do, and how all those things mesh up. And then going back to that why, maybe we have this long-standing legacy plan. Maybe we have children from separate marriages. Maybe we just generally want to make it as simple and easy for all of our heirs. All of those can be okay answers, but we need to start thinking about that as we prepare to meet with the estate planning attorney. And even though we've brought up a lot of topics, I always try to remind clients, we don't have to have all these answers. The experts that we're sending you to, these estate planning attorneys, have gone through this process with so many. So maybe as long as you're starting to think about that, they can help you answer some of the questions. Maybe they can help formulate what it really is that you're trying to accomplish in your goals. So don't ever let these aspects delay you from having the meeting. And ideally just start to have that picture in your head so you're prepared to have a very beneficial conversation when you have that first meeting. But I think I'll wrap it back up to the beginning. We try to do a good job to stay on top of you, to remind you that this is important and to make it happen. Sometimes clients don't like to think about these end of life or incapacity scenarios, but it is very, very important. So if we're not asking enough, let's both just try to do a good job of reminding each other that we have to readdress these items pretty often, just to make sure that nothing's changed in there.
Those are all really good points, JP. Thank you for sharing that. I think to summarize what you just said, it's real important to be working with your personal wealth advisor, really in preparation of sitting down with that estate planning attorney, because there are a lot of factors to think about, and you want to make it efficient for everyone involved. And some really good ideas can be shared on, suggestions on what the client should think about. So thank you for sharing that. All right, Sarah, next question's for you. We'll go one more round of questions before we open it up to the audience. JP mentioned outdated documents from time to time as we see and work with clients. What would be your recommendation on how often someone should be reviewing their documents, and when should somebody be making changes?
We see it all the time. We see outdated documents all the time. And part of my specialty is elder law. So it's planning for people who are in the aging process. And sometimes they come in and they've got old documents and it's too late to update anything. So I see the real problems that happen. I worked with a gentleman this year whose mother passed away. And the last time she updated her will, he was 4. So, he's a grown man, so it named aunt to be trustee and handle the inheritance for him. But she's, in her 80s and has poor health. So it can create a real mess if they're not updated. It's also not uncommon for us to see packages from the past 10 or 20 years where the tax laws were significantly different. So there's a lot of complexities in there as it relates to planning for the spouse, planning with trust that just aren't necessary anymore, and will make things a lot more complicated. Our rule of thumb that we tell our clients when they leave the office is take a look every 3 or so years, which sounds like a lot, but there are so many things that can happen that would change the who or what or when or why that JP was talking about. Major events like a birth of a child, the death of a family member, a marriage or divorce, acquiring rental property, acquiring property out of state, significant change in wealth, a health event or a diagnosis. So the idea is that if you have a plan in place, you're in a good position and you're ahead of the game, because I think a majority of Americans don't even have anything in place. but you can't take for granted that you're just good to go and you're good to go forever. You've got to keep an eye on it. We had a major change in power of attorney law a couple years ago, and a lot of clients were interested in updating their documents to be in conformity with the new law. So you just don't know what's going on out there.
Yeah, that goes a lot hand in hand with what Tim was saying earlier about updating the beneficiaries too, as you go through those life events, whether it's losing a spouse or going through a divorce or having another child. That makes a lot of sense. It's really a good life event, rule of thumb to be evaluating your estate plan. So good. All right, Tim, next question. We've talked a lot about the three main estate planning documents: the will, the powers of attorney, the advanced healthcare directive. Let's talk a little bit about trusts. And one of the more popular trusts, what's called a living trust, also known as a revocable living trust. Talk to us about trusts and who a living trust might be appropriate for.
Sure. And so I would start off by saying there are hundreds, if not thousands, of different flavors of trust. So be very careful after this webinar of going on the internet and looking this up for yourself, because there is so much misinformation out about trust out there. The most common form of trust that I see these days is a revocable trust, also known as a living trust that Bill touched on. And what I refer to the revocable trust as is a will substitute. So instead of having the will control how certain assets are passed, the trust now controls that. And when I am meeting with my clients and I'm talking about creating a revocable trust for them, I explain it like this. I am creating a bucket for you, and while you are alive and while you have capacity, you can put whatever assets into this bucket or take whatever assets out of that bucket that you want to. They're your assets to do with what you want. When you pass away, or if you become incapacitated before you pass away, you have a mechanism where that bucket of assets gets passed off to the next person in line to manage. And so what is the difference with that and a will? When you have the revocable trust, as Bill touched on, it is also called a living trust. It's created now, and you're using it now in your lifetime. A will is strictly what I call a death time document. It means absolutely nothing while you're alive. And when you pass away, somebody, your named executor, must take the will down to the probate court and be appointed executor of your estate. And that is what is commonly referred to as the probate process. The probate process is proving a will to be valid and appointing an executor to carry out the directions in the will. So Georgia is typically what I call a will-based estate planning state. And that is because, without getting into too many details, the probate process in Georgia is not particularly difficult. It's actually a relatively streamlined process. But that is the first reason that people would want a revocable or a living trust as opposed to a will-based plan, is that the assets in the bucket are completely outside of the probate process. When you die or if you pass away, those assets immediately pass to the next person with no court involvement. And a lot of people like that. I have had more and more clients who, even though the probate process wasn't a big deal, they were executors of an estate, and they just decided, you know what, I don't want my beneficiaries to have to go through that process, so I'm going to establish this revocable trust. Typical reasons to avoid the probate process would be if you owned real estate in another state, because anytime you own real estate in another state, you have to open up probate in that estate, and that can get very expensive. Also, if you have concerns about an heir, a child, or another beneficiary, somebody contesting the validity of the will, it's easier to contest the validity of a will than to try to attack a revocable trust. It's just, again, without getting too much into the weeds with that, it's just a much more difficult process to attack a revocable trust. The second reason why you would want to have a revocable trust over a will is privacy concerns. When a will is entered into probate, it becomes a public record. And traditionally, most of my clients anyway, didn't care about that, primarily because you would have to go down to the courthouse and pull the will out of the court records to see what's in the will, and very few people do that. More and more probate courts are putting their documents online, and I would guess in the next 10 years, any will that's probated will be able to be accessed through the internet. The final reason is management during disability. And Sarah earlier touched upon, in her 3 foundational documents, the financial power of attorney. If you have a will-based plan and you become incapacitated, somebody needs to take control of your property, they need to use that financial power of attorney. And it's not the end of the world, but that person does have to go to each financial institution. They have to convince everybody that they do have the requisite authority to act with regard to the incapacitated person's property. With a trust-based plan, again, we have a mechanism where the bucket gets transferred to the next person in line upon your incapacity. And that person is called the successor trustee, and they clearly have the authority, and it's backed by statute and law, to act on behalf of whatever is in that bucket. And I see that still, even though probate avoidance is getting more and more of an issue, even in Georgia, being the primary benefit for people to have a revocable trust in Georgia. Keeping in mind that if you're one of those people like me who have most of your assets in a 401k, then there's certain assets that can't go into that revocable trust. So there's never a one-size-fits-all answer. Do I need a will-based estate plan or a revocable trust-based estate plan?
Good. Thank you, Tim. JP, as you help your clients prepare for those estate planning meetings, a couple of the roles that you mentioned earlier are trustee and executor, and Tim even touched on the executor and the role of the executor. But can you provide maybe a little more clarity on the differences between those two and the importance of making sure you've got the right person serving in that role?
Sure. So, I think Tim just touched on a lot of differences between when you have a will-based plan, you got to go through probate, which means you have an executor, versus why you have a trust and a trustee. I have a tendency to think, in 2 different categories for my executor. One is if it is a will-based plan and you do have probate and you have this executor named, it's a very administrative function. So locale may be a big deal if you are here in Georgia and all of your assets are largely here in Georgia and you have a will-based plan, but you name an executor that might be in California, going to get sworn in as executor and to try to do some of the administrative functions of aggregating all the assets that are intended to pass by will through the probate process can be a little bit more difficult for someone out of state. And so you want to be thinking about a person that, one, doesn't mind doing some administrative tasks. It could be everything from cleaning up a house to get it to be sold to taking everything and titling it through the estate. But I think very much of an executor as someone who has a lot of administrative function having to go before the court. And I think of them as the duration, hopefully, of their span to serve is rather set in time. There's certainly some different will-based plans that Tim brought up where you have someone who contests the validity of a will. So the stay of an executor in their function can be extended depending on what happens as that will tries to go through the probate process. But the hope would be that they can administer that rather quickly, get through that process, but don't mind serving in that, or are very good at hiring a third party to help them through that process. The trustee, on the other hand, usually if you've built a trust, and Tim brought this up as things that, go from potential different generations or longer time frames, that trustee is probably going to have a longer serving role as a fiduciary for the assets that you've placed in that trust and the rules that you've placed in that trust. And so the coordination of maybe a lifetime giving that's going to happen to a beneficiary or otherwise. So you're going to ask them to serve for a lot longer, depending on where that trust is intended to go or how long it's going to last for different beneficiaries. And there still is a very much administrative function to it in making sure that the trust is going to file its annual returns, depending on where that sits. Or they're going to have a lifetime connection with some of the beneficiaries that you've named in your trust. So each one of them has some definitive roles to serve and to uphold your wishes, but one may have a little bit more administrative function that goes throughout the courts and just getting things aggregated up, and hopefully that there is an end period that happens unless there's some contested nature. And again, it may also just involve a little bit more of walking in and out of a courtroom and getting things retitled, versus the trustee steps in and kind of serves as a fiduciary to something that has largely already been put in place. They have some very specific rules they have to uphold to, but they're likely going to have to serve for a much longer time frame. So I think there's some similarities when you look at the two, but certainly some larger differences when you're thinking about what you're asking those two people to do and how long you're asking them to do it. Yeah, that's it.
That's good. Thank you, JP. All right, we're at a point now where we'd like to turn it over to the audience. As Nate mentioned earlier, there is a Q&A function at the bottom of your screen where you can click on and type in a question. We have received our first question from Jay. All of our legal documents were created when we lived in Arizona. Do we have to update our documents here in Georgia? And also, what happens if we don't? And I'm going to give Sarah the first crack at answering this particular question. So Sarah, how would you handle that?
I think there's really two questions. One is, do we have to? And the other is, should we? Do you have to? Probably not. I've never seen a set of documents that was valid in that state and wasn't valid here, but it can make it harder. So as an example, I'm working with a gentleman now whose mother passed with a Michigan will. And the wording and the signatures isn't quite in line with what Georgia requires to get it through the probate process in the easiest way. So what that meant was I had to go track down one of the people who witnessed this will. And I had to get them to fill out an interrogatory form about the will signing that happened years ago and notarize it and send it back. And I was looking through the language again and I said, in Georgia, we say, well, the executor doesn't have to file inventories and returns, and then it makes the process really easy. But that specific language isn't in that will because that's not quite how they do it in Michigan. So then I had to file another piece of paperwork to make it move. So I think the cost and hassle factor, if you don't have state-specific documents, can be significant. Power of attorney is another example. Is it legally valid here? Sure. But if you take it to the bank, are they going to require or request a Georgia document? Maybe. And you don't have the protections of Georgia power of attorney law that's out of state. So those are a couple issues that can come up.
Great. Thank you, Sarah. And thank you for the question, Jay.
And I'll add one other thing to Jay, because I lived in Arizona. One of the bigger differences for Arizona and Georgia is Arizona is a community property state. So the titling differences versus Georgia and Arizona, and maybe some of those specific items that are addressed in an Arizona will when it comes to community property, have nothing to do with assets and now living and domiciling yourself in Georgia.
Good. Thanks for bringing that up, JP. I'm glad to have you here in Georgia. I'm glad you moved here from Arizona. All right, next up, I have a question here for Tim. This is from Neil. What is the best way to protect my assets that I intend to pass on to adult children, but not future spouses of the children if they get divorced?
Through a trust for the child. And there are many different levels of of protection that you can provide for an adult child. To take a step back, without a trust, if you gave an inheritance to a child and they kept that asset separate, they didn't commingle it as a marital asset, they always had it in a separate bank account. The law says that those monies should not be part of an equitable division in a divorce proceeding. But many times those assets do get commingled, so they become marital assets. And my family law attorney, my divorce law attorney friends will tell you that if the money is in an account that's not protected by a trust, they're certainly gonna take a crack at getting some of it. If you put the money into a trust for a child, I always look at it like a flow chart. You can create a trust for a child, either through a will or through your revocable trust, and you get to decide who the trustee of that trust is. And the first level of protection is creating a trust for the child and having the child be the trustee of his or her own trust with full access to the assets in that trust. Now, nothing would stop that child from taking all the money out of the trust and putting it into a marital account. But I find that people generally, when they receive money in a trust, even if they're their own trustee, they handle it with more deference. The second question on the flip chart would be, well, I could name a third party as the trustee. And then you would have a much heightened level of protection for the child in the event of the divorce. That's the plus, but the minus is now you have a third party trustee who's going to get paid, and your adult child beneficiary will have to come to that trustee every time they want to take a distribution out of the trust. So there's always varying degrees of protection, and it just depends upon how much control you want to leave with your adult child.
Good. Thank you, Tim. So we've started off with two really strong questions. We've got another one here from Ray. I'll let Sarah address this one. Any suggestion on how to manage the trustee duties within a trust? Seems like a lot of different scenarios with an independent trustee, a trust protector, successor trustee, a special trustee, etc. How would you address that question, Sarah?
I kind of relate back to how JP described it in terms of who the person is and what we're wanting them to do. Because I guess the most simple way to put it is a starting point when you're creating a trust is you can just have one trustee and they're in charge of everything. It's like they own the property, but it's not for their benefit. So they can handle investment decisions and distribution decisions. Maybe in your scenario where you're thinking about the who's, you think it might make more sense to differentiate that, to have an investment trustee and a distribution trustee, and you can carve it up like that. Or maybe you're concerned that one trustee in charge of everything, that level of control and maybe like a lack of oversight gives you pause. Well, then you can have a trust protector, someone designated to monitor what's going on. And what I love about a trust is that like Tim was saying, there are 1,000 different possibilities. You can take your scenario and you can build something that makes the most sense in terms of your who, what, and why. Sometimes when we're naming individual trustees of their own trust, we want to put some limits into what they can do because it's beneficial for creditor reasons or tax reasons. So that might be a reason we name an independent or a trust protector or the option to have an independent trustee. But you really got to get down to the meat of why you're doing what you're doing, and then you can build the trust around that and designate the roles around that.
Good. Thank you, Sarah. All right. Next one is coming in from Mr. Milam, and this might be a difficult one to answer, but I'm going to let Tim take first shot at it. What types of assets cannot be placed in trusts? Would benefits from a retirement plan, such as a SERP, be eligible?
For qualified retirement plan accounts, the distinction is that the trust cannot own the actual account. but the trust can be the beneficiary of the account. And with the passage of the Secure Act now, there are some questions as really, do you want to pay higher taxes, or do you want creditor protection for the assets that are in those qualified retirement plan accounts? It gets tricky, but the short answer is no. The trust, either a revocable trust or a trust created under a will, cannot own the retirement account, but it can be the beneficiary of the retirement account, of the proceeds that pass out of the distributions that pass out of the retirement account.
Good. Thank you, Tim. Next up, Sarah, I'm going to offer this one to you. What happens if you have a beneficiary designated as the estate of, quote unquote, and this is from Steve?
So essentially that pours that asset over into your probate estate. So as an example, if you have a life insurance policy and it's made out to the beneficiary as the estate of, ultimately your executor is going to receive a check for those proceeds made out to the estate of Sarah Watchco. And that means that my will needs to be probated, an estate needs to be opened, an estate account needs to be opened, the money is deposited into the estate account, and then my will controls where it goes. So on the one hand, if I want my will to control what happens to those monies, maybe it makes sense to do that. On the other hand, there are some benefits to having a beneficiary designation that you might lose. For example, I mean a person as a beneficiary. For example, if a person is named, it passes free of creditor claims. So if there are creditors and it goes to my estate, my creditors get a bite. Also, usually if you name an individual beneficiary, that's a very efficient process. The beneficiary fills out a form, gives a form back with a death certificate, and gets a check or gets the transfer of assets versus it having to go through the whole estate probate process.
Good. Thank you, Sarah. I'm going to offer one to JP here. This one's coming in from Mark. Can rollover IRAs and or individual stocks be inserted into a living trust without paying taxes or changing the name on the stocks? So JP?
Yes, I think we addressed a little bit about the IRAs, right? The IRAs, retirement accounts, individuals own those accounts, especially while living, but we can name them as beneficiaries. So they would then the trust could then inherit the asset when you pass away and have specific trust rules for the trustee to manage those assets after your passing. But while I'm alive and I'm an individual owning my retirement account of whatever color or flavor, it has to be in my individual name. For separate stocks, so whether they're in a brokerage account or with a direct investment institution, whatever that may be, you can, as my grantor, just move those over. And you don't have to sell them. You don't have to recognize capital gains on them while you're moving those assets into trust name. The element of what happens with cost basis or distribution, a lot of that's going to have to do with what's going to govern later on in the trust document. But right up front, no, you can just move those things on over into the right titling. If they are in after-tax account or non-qualified accounts that we'll sometimes call IRAs and 401ks, we just pick them up, move them over, and manage them basically as our own during our lifetime. There's some other complex issues if you want to do some lifetime gifting to a trust that is not a living trust, and you are truly trying to get those assets out of your estate for estate tax purposes or things like that. That's probably the second a little bit more complex, but generally speaking, the answer is yes, we can pick them up and move them pretty easily.
Well said, JP. We still have some really good quality questions coming in. This next one's for Tim. This is from Ms. Edmond. For Tim, would you advise a senior, if their spouse has passed away, to change beneficiaries to adult children or a child, or are there some other options?
It depends on your individual circumstance, but if you have adult children who you feel are responsible enough to manage the money. It's not always an age consideration, but just where they are in their lives. Then certainly I would name the children as the direct beneficiaries of those types of assets, because to Sarah's point, if you can avoid the probate process, all things being equal, we would like to avoid the probate process. Filling out a form and producing a death certificate is a lot easier than going through the probate process. So the question is that child capable in my eyes of managing this money responsibly? If yes, make them a direct beneficiary. If no, then think about options in terms of the creation of trust to protect those children.
Good. I love this next question for Sarah from an anonymous attendee. It's a Secure Act question. So how did the Secure Act affect retirement accounts, 401k, Roth IRAs, etc.? Sarah?
Tim Curtin very kindly nominated me to answer the difficult Secure Act questions. Just want to point that out. The Secure Act was a major change to the rules related to how beneficiaries take retirement accounts. So if you think of an IRA we'll use, for example, if I have my own IRA, when I turn 72, I have to start taking required distributions and I pay ordinary income tax on that. And that's a concept we're all familiar with. Under the old rule, when I died and I went to my beneficiary, unless my beneficiary was a spouse, let's say it was my adult children or minor child, they had to start taking those same kinds of distributions no matter their age, but they could take them throughout their entire life expectancy. So it extended the amount of time those funds could stay in the IRA. And we want the funds generally to stay in the IRA as long as possible because it's tax deferred, and so they grow more than if you had to take them out and pay income taxes on it, then pay capital gains and all that. So beneficiaries had a life expectancy over which they could withdraw assets. So I'm 37 and I inherit an IRA, I got decades. The Secure Act changed that to 10 years. So except for a limited number of exceptions, and surviving spouse is a big exception, the rules relating to surviving spouse did not change. But if my child inherits my IRA, let's say it's a $2 million IRA, my child gets it, over the next 10 years, they've got to withdraw that from the IRA. They can do it in year 1 or year 10 or a little bit each year, but every dollar coming out of it's a traditional IRA, they're going to pay ordinary income tax on it. And what happened was the federal government bumped up the age to 72 as to when you have to start taking distributions to help retirees, and they had to pay for it. And this is how they're paying for it. They're making the beneficiaries take it sooner, pay the income tax, and that's the balance.
Good. Well said, Sarah. All right. Next question for Tim. Any advice on how to address assets and real estate that are in a foreign country? This one's coming in from Matt. Good luck with that one, Tim.
The first thing you have to do is find the treaty that we have with that country. We have a treaty with almost every country regarding how those assets will be distributed. Some countries have very strict laws about how assets of real property can be distributed. Generally speaking, in my practice, I'm dealing with this right now with a couple who has real estate in France. You have a U.S. will that disposes of U.S. assets, and then you have a French will that will dispose of the assets in France. It generally does not lend itself to, for example, put French real estate into a United States revocable trust. So you need a separate document from that country to control the distribution of that real estate.
Good. Thanks, Tim. And Matt, thank you for that question. I'm going to break this next question up into 2 parts. This one's coming in from Steve. So, JP, are there different tax consequences between a will and a trust?
I guess, there's two things to think of. Remember, the will is our document that says, hey, we've passed away now. What happens? A trust can be a living trust, or there can be testamentary trust. And so there's a difference on how trusts are taxed when I'm alive. If they're inside of my living trust, it's just like me paying taxes on those trusts. But if I'm no longer around and that trust is now either irrevocable or something's happened, then the trust has its own tax rate versus me paying them as an individual. The will is, if I think about what's happening with my estate and how that final estate tax return gets filed, there are some elements that will be different there as that estate having to file it. And it probably lends itself back into, hey, when do I have to pay estate tax, right? I mean, the world of today is so much different than it was a couple of years ago, and especially going back 10 years. Now, if I die and my overall estate as an individual less than $11.4 million, I don't have to pay any type of estate tax. And then you also, if I'm married, you get to double that. And they've made it a lot easier to make sure as a married couple, you can fully use that almost $23 million exclusion. So the answer is yes, there are some different tax consequences, mainly having to do with if I have dollars in a trust today, I get to, if it's revocable, I get to treat it as if it's just my own asset, versus once we've passed away, a trust is now irrevocable or it has a long lifespan, it's going to have to pay it at its own tax rate.
Good, JP.
Which trust tax rates, just so everyone knows, trust tax rates accelerate pretty quickly. So you get into high brackets pretty fast.
Yeah, to the top brackets, relatively quick. But I'm going to add to that second part of Steve's question, and I'm going to ask this of Sarah. So, over the next 5 years, what do you think is going to happen to the estate unified credit and what that looks like? JP threw out some pretty big numbers, almost 11.5 million per spouse, so we're looking at 23 million right now, but what's going to happen over the next 5 years?
What is slated to happen is that the current schedule expires at the close of 2025. And then 2026, it reverts back to 2017 numbers, which is 5 million per person. And that there'd be an inflation adjustment. So it would be more than 5 per person. So more than 10 for a couple. What's actually going to happen, I have no idea. Depends on which expert I ask. Could a different administration, different representatives in Congress make a difference? Certainly. Some say it's never going to go back down. It'll never go back down below 5 million, and I like to think that's the case, but I know better than to say things will never happen. So it's slated to go back, but we don't know.
Well, we have another expert on the call, Tim. What are your thoughts regarding that?
I couldn't agree more with Sarah. It depends on all that and who's running our country next year in Congress. So it's really a guessing game. You didn't ask me this. My personal philosophy is don't do planning based upon what might happen that we have no control over. That is why everyone's talking about reviewing estate planning documents every 3 years. I send out a newsletter to my clients every month. I know Sarah's firm has a great newsletter they send out to their clients. If something changes, you will hear from us, and then we plan accordingly based upon what we actually know is going to happen, as opposed to what we are wondering but have no real idea.
Yeah, that makes total sense. Well, good. Looks like we've answered all of the audience questions. Please feel free to reach out to your personal wealth advisor if you have follow-up questions or want some more clarity regarding your individual situations. And Tim and Sarah and JP, I want to thank you very much for joining us today on a panelist discussion about estate planning and trust. Thank you, everyone. Hope you have a fantastic Friday and rest of the weekend. Thank you.